Hello everyone, welcome for joining me. Right, so there's been a few filings I want to go through. So I'm going to try and do that. The main one I would want to do is obviously Blake Lively's motion for fees, costs and damages. But there's another one that's come down, so I'm going to quickly go through that first, I think. Just want to put my disclaimer up though, my comments are opinions only and they are not intended as legal advice. Right, okay. So I'm going to be sharing screen, which means I probably won't be able to read comments. I'll have to keep dipping in and out. Hi, Jane. Hi, Robin. So yeah, I'll have to keep coming back and forth, but yeah, I'll try to get to people's comments and questions and things. Hi, Gwen. Right. Oh, it'd help if I actually shared the screen. I always forget to do this. I'm still really new to all of this. Yeah. So this is the judge's order on the motion to compel Coslow and Case. So the judge held an in-camera review of documents that were involved in a discovery dispute. Coslow and Case had basically said, well, these are privileged. Lively said, no, they're not. Basically. But then, so the judge ordered an in-camera review, which means that the judge behind closed doors looks at the documents and determines whether they're privileged or not. And today we got his order. So we go past all the background because we've heard it so many times now. Yeah, she's claiming she was sexually assaulted, blah, 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 and they're all smearing her. So the first category of communications that the judge spoke about were the text between Case and her father, who is an attorney. So what the judge said basically is that the text do not suggest legal advice was being sought. Case alleged that she had retained her father's firm, but she hadn't actually provided anything to support that. So what the judge means by that is like an engagement letter, evidence that legal advice was given, a conflict check. So, attorneys do conflict checks to make sure that they're not, or like for instance, already representing a party in it. There was no affidavit. That was the other suggestion the judge made. So there was nothing really there to support or evidence the fact that Case had retained her father's law firm. And then the judge did say as well, some of the communications concerned, discussions around the family dog, a movie that her father was watching, those kind of things, which are clearly not legal advice. So due to the lack of evidence to support the existence of any attorney-client relationship, the judge has said that there is no privilege on these communications. I suppose it's questionable, how relevant is text message between a father and daughter about the family dog? How relevant is that to Lively's claims? But nonetheless, she's asked for it, and because there's nothing to prevent it being handed over, the judge has effectively ordered that it be turned over. Then, what was it? So the communications that do not include counsel. These communications concern populating the website. So this is obviously the lawsuit info website where they uploaded the First Amendment complaint and the Exhibit A timeline. The judge says that the communications concern populating the website and no legal advice. So effectively, they're not privileged now. The judge did make a little typo here. These communications were not made for the purpose of obtaining legal advice, and as such, they do qualify as privileged in the first place. That probably should have said do not or don't. I would have thought do not. So that's a typo. It's referred to as a Scrivener's error, which is basically an error made on a legal document. It will probably be rectified with a corrective order. So the fact that the typo exists won't change anything here. Documents including Kalantari, is that right? Kalantari and Wallace. Okay, so the judge made a note in the footnote at the bottom here that they do not assert work product protection over any of these documents. And I think that if they had, it may have made a difference, but they didn't. The judge says there's no attorney-client privilege. Simply including attorneys in communications does not automatically mean that they are privileged. And actually, Wallace's inclusion waives that privilege. So these communications were not privileged, and they also have to be turned over. I am making this kind of really condensed because I want to get into the other motion. Okay, documents withheld on work product grounds. So the judges basically said that some of these communications are PR, which is mixed with legal strategy, which cannot be separated. Other communications are just purely PR. So work product applies to several communications, which we don't know what they are at the moment because they're still sealed. But it doesn't apply to all of them. So there's a bunch of stuff here. The following materials may be withheld on the basis of work product privilege, but we obviously don't know. And there's a couple of exceptions, but I think most of this category of communications is been granted privilege. So where privilege has been applied, they will not need to be turned over, but where it has not been applied, they will need to be turned over to liability. Communications between attorneys and clients withheld on attorney-client privilege grounds. Okay, so again, much like the last one with the work product grounds, the communications between attorneys and clients withheld on attorney-client privilege grounds. Some communications are privileged and some are not. So I think here, so there are these communications here are privileged. Again, it's really hard to say what they are because I don't know. But the judge did find that some of the communications were purely for the purpose of freedmen obtaining public relations advice, and those ones are not privileged. So, in short, the motion to compel is granted in part, denied in part, and the documents that have to be turned over need to be produced by the 12th of September. So that's that filing out the way. Hi, Joe and Elizabeth. I'm just seeing. Hi, Lara. Oh, and Girly. Hi, Girly and Sean. Right, okay, so I'll try to get to the motion now, actually. Okay. I think this is the right one. I've got a few tabs open, so I'm just checking what I've got. Okay. So Blake Lively has filed this motion. She is seeking the attorney's fees, treble damages, and punitive damages under California Civil Code Section 47.1. I wasn't sure if she was going to file it, to be honest, because it's been like months since the motion to dismiss, where Wayfarer's claims were all dismissed. And I wasn't sure if she was going to file it at this point or if she was waiting till towards the end, the trial date. But we have it. And I think it's just raised more questions than it's answered for me, I think. So I want to say, though, before I kind of read it and go through specific points, this is a case of first impression. So there is no precedent here. 47.1 is a state law, Californian state law. I'm having a hard time thinking that Judge Lyman is inclined to rule on this because, he's a New York federal judge for a start. And I do feel that if he was going to consider this, he would have indicated in the motion to dismiss. But he specifically did not look at 47.1. 47.1. He did not look at the amicus briefs. He did leave the door open politely to file this, which is obviously why we've got it. There's probably a number of reasons why he may have done that. But I don't think that he's going to rule on this. And if he does, because I don't want to just sort of say, well, I think the judge is going to do this, because nearly every time I've had an opinion on this judge, he has done the complete opposite. I think if he is going to rule on it, he'll probably do it after the trial. I don't think, like, she's asked for a hearing soon to get this sorted out, like now. I don't think she's going to get that. I will be really surprised. So there's a few things. I'm not going to go over I'm not going to read this word for word. Lauren already did a great job of that. And we know most of the background. So she's obviously seeking remedy for her sexual harassment claims, not for her claims, for the fact that she feels that by initiating a defamation claim against her, Wayfarer retaliated against her. Which, that's one way to look at it, I guess. I don't agree with that. And I don't agree with this law. I've said it a number of times. I feel like there is no safeguard for people who are falsely accused. And that's not just limited to men. Women can also be falsely accused. I find it really troubling to have a law like this in place where potentially by, say, calling someone a liar or, taking action to defend yourself, defend your reputation, defend your family, defend your business, that you can then be punished in this way. Because that's what punitive damages is. It's a punishment. And also it's supposed to act as a deterrent, which is incredibly troubling. One thing I was a bit... there's this section here actually. Sorry, I don't have a script, so I'm just looking through, trying to pick out what I want. This part bothered me a bit. Specifically, Section 47.1 is intended to defer frivolous claims that force survivors, which she is not a survivor, to defend against a long and expensive retaliatory defamation lawsuit by imposing significant remedies for successful defendants in defamation claims. Moreover, because Section 47.1 is intended to protect victims from the litigation itself, these remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. Consistent with Section 47.1's stated purpose, the court should act promptly to remedy the substantial harm Miss Lively has incurred. Now, I have, okay. So this is the California Code. This is Section 47.1. And it does, nowhere in this does it say that it needs to be at the motion to dismiss stage. Nowhere. So that is something I remember when I did one of the amicus briefs. I did a thread on one of the amicus briefs, and that was the first time I'd ever seen it, a reference to, she should not, she should be let out of this lawsuit at the motion to dismiss, because anything else is just torture and you're making her relive her experience and all the other kind of victim buzzwords. That was the first time I'd ever seen any reference to Section 47.1 should take effect at the earliest stage, the motion to dismiss. In the law itself, it says no such thing. It actually says that you have to have had at any time a reasonable basis to file a complaint, and it has to, your complaint, your basis for having having a basis to complain has to be free of actual malice. And if you're having your case dismissed at the motion to dismiss stage before discovery, then how are we establishing whether the complaint that Blake Lively whether she had reasonable basis, whether it was in good faith, and whether it was free from actual malice? How were we able to do that? And that's my first problem with this. So yeah, the other part of my thinking here is, and I find it a little rich that she's put this. Sorry, I'm just looking for it now. Yeah, so I mean, they're talking about, to protect survivors. So these remedies must be available at the earliest stage, typically to protect survivors from a punishing, protracted legal process. Blake Lively initiated her legal process. She filed the CRD, then she filed the New York lawsuit before Wayfarer filed anything. So there has to have been some acceptance that you were going to go through the court system, that you were going to go through discovery. Even with Wayfarer's lawsuit gone, she's still got her own lawsuit. So I have an issue with what she's saying, and just the laying it on so thick, or using language like survivor. For me, the term survivor that should be really, and I'm not diminishing anyone's experience here. I'm speaking from experience too. If my employer said something that made me a bit uncomfortable, it would annoy me. And I have had that. But I moved on from it. And her claims, now bear in mind I'm talking specifically about her claims and the evidence that there are for them and the lack of evidence for them. But based on the claims that she's presented, I do not see her as a survivor. Even if they're true, to me, the term survivor is a very serious term. That speaks to me that someone got out of a highly abusive marriage. They literally survived. And I think the word in this filing, being used in this filing, it has no place. But I don't believe her claims, so that's where I am there. I'm just checking chat, sorry. Hi everyone. Yeah, exactly, Jane. It's a California law. It's never been ruled on. Why would a New York judge make the first ruling? I don't think he wants to. I really don't. I think if I had to be pinned down for a reason, why do I think he left the door open in the first place? I think it's so that he could, make it harder for her to appeal and say, well, he shut the door, so I'm going to appeal it. I think a lot of what this judge has done has been to mitigate against her the likelihood that she'll appeal. But I don't know. I'm not a bot. Hi. Do I think Jed, Brian, and the rest will turn over physical phones? Yes. And that will have happened on vice versa as well. So that will absolutely be happening. But Blake Lively will have had to do that, and her various witnesses, etc. They will all be, the parties certainly will be doing this. So. All right, okay, let's go back to the filing. So she obviously talks about how we got here, basically. I also want to say as well, specifically section 47.1 is intended to deter frivolous claims. No one has actually said, including the judge, that Wayfarer's claims were frivolous. He said they weren't well pleaded. But that does not mean that they had no basis for them at all. In some of them, he dismissed without prejudice, so they were able to be brought back if Wayfarer had chosen to. They have not done that. So she she talks about the various retaliations that she's experienced since she filed her lawsuit as well, which is it's basically another rehashing of her sanctions filings. Technically, though, here she is right. She is technically a prevailing defendant. So, which, if she meets all the elements of section 47.1, she is making an argument, a reasonable one, that she's entitled to all these damages and fees and costs. It's whether she's, like I said before, was the complaint made in good faith? Was there any malice? And I think that's the bit that we need to, these terms have legal definitions. Actual malice has a legal definition, which I actually did way back, months ago during when the motions to dismiss were filed by the parties. So I've got that actually to have a look at, which I will do in a bit. But we're going to get to the Steve Sarowitz parts. Oh, right. I can't even believe that she's put these in here. So, Steve Sarowitz. This quote that she's put in bold and italics. She's only put half of the quote in bold and italics, so she's sensationalizing the bit that suits her argument. So we now have a full quote as well, because her other filings have not had the whole thing in there, but now we've got the full thing. And for me, when I first read it, it sounded like the worst ever threat. It really was. It was like a bumbling word salad. I will protect the studio like Israel protected itself from Hamas. There were 39,000 dead bodies. There will be 2 dead bodies when I'm done, minimum. Not dead, but you're dead to me. So that kind of dead, but dead to a lot of people. If they ever get me to that point, then I'll make it worth their while, because I'm going to spend a lot of money to make sure that the studio is protected. That sounds like no credible threat. Do you know what I mean? It's like someone coming up to you and holding a knife to your throat or something and going, look, if you don't give me your money, then I'm going to stab you in the neck. Well, not stab you. I might just give you a little scratch, but, it won't hurt so much, but, it will still cut your skin. And it's just like, do you know what I mean? It's like, I feel like he maybe, again, this statement has not actually been verified, by the way. We have not seen evidence of who it's said to or what the context is, like what was the discussion leading up to this? Did someone say that Lively/Reynolds said something about Wayfarer and this was like just a off-the-cuff response? It's clearly not serious, because, like she's boldened the bit where, up to the point where he says there will be 2 dead bodies when I'm done. And is in the footnotes is trying to stretch that to mean to be some kind of threat for her life that she took seriously. But then he's also saying, not dead, but like, you're dead to me, kind of like, and you're dead to me means basically, I don't want to know you. I want nothing to do with you anymore. It doesn't mean he's going to kill anyone. But it's just like the Madison Square Gardens comment, which is like so throwaway, but she has thrown it in to be a security risk, a threat to her, trying to embarrass her, selling tickets, to mock and humiliate. And it's grossly overblown, to a point where I can't take what she says seriously. And I don't think a lot of people can, actually. And the worst bit is when Steve Sarowitz was actually asked about this comment, in the link that Lively herself has put in the footnote, he says that, it was confirmed that Steve Sarowitz was prepared to spend whatever was necessary to defend Baldoni Wayfarer Studios, which is co-owned by him, and himself, who is being sued. And I don't understand why Lively thought that would help either, because that confirms his intention behind the comment, which is also at the end of the quote itself, of the actual comment quoted here. I'm going to spend a lot of money to make sure the studio is protected. I think Lively's been absolutely ridiculous, and I'm so sick of seeing this comment. And when we weigh up Lively and Sarowitz, right, and we look at which one of these individuals has actually faced a genuine, real-life threat of harm to them, their family, their property, because of these statements that Lively is putting in her complaints and attributing to Steve Sarowitz, the only person who's actually, experienced a real threat is Steve Sarowitz. When someone attempted arson on his property and attempted to extort him under the threat of kidnapping his daughter. Lively has not experienced a genuine, serious risk of harm. So I feel like she needs to knock it off. I'm getting quite annoyed with this. Let's have a look. Let's have a look at the chat, actually, see who else there. Right, okay, so she obviously goes through and details what happened, the timeline of events is what a lot of this is. So what happened from the point she filed her CRD, which is, it started with even Friedman responding. So she filed her CRD, the New York Times published their article, they went to Wayfarer parties and Brian Friedman for a response, and Lively is even saying even that response is retaliatory, which is crazy. It really does. I really am getting the feeling that she is just trying to silence them. When you look at the motions for sanctions, 2 different motions for sanctions for essentially the same conduct, basically, against Brian Friedman, and a threat to file a motion to revoke his pro hac vice status if he didn't stop making comments. And Brian Friedman, I haven't even heard him make a comment for months now. But she is clearly triggered by him. Okay, so she's going through and she's talking about the motion to dismiss. So they all moved to dismiss their claims. I mean, most of it is just going back and forth about what happened. So we can skip over that because we all know in graphic detail what happened. So we're at the point where the court grants Miss Lively's motion to dismiss the first amended complaint with prejudice. And she's trying to mold the judge's comments in the order, in the ruling. She's trying to make them fit, and they don't necessarily fit what she's saying. So obviously, as we already know, the judge did not decide did not rule on section 47.1. He did not look at the amicus briefs. He very clearly made a point of saying that. And she's just inserting a bunch of stuff here, comments from the judge, which I think she's taken a bit out of context. You know, a lot of us weren't happy that the judge was making some of these speculative comments, you know, such as this one, given the strength of evidence in favor of a smear campaign. Lively is, you know, putting that in there, suggesting that, you know, it's a done deal. The judge thinks there's a smear campaign, but that's not what actually happened. But Lively is trying to make this fit. Now, as section 47.1, you like one of the requirements was that the communications, the protected communications, cannot have been made with malice. And Lively is pointing out that the judge, in his motion to dismiss ruling, found that Sloan and Reynolds did not have actual malice, and the New York Times. But the reason that he made that statement, if we go to the actual motion to dismiss ruling, it says here quite clearly in this footnote 59, in addition, the amended complaint does not allege actual malice as to the Times for the same reasons as it does not allege it as to Sloan and Reynolds. The Times had no first-hand knowledge of the allegations or reason to disbelieve them. So what the judge is saying there is, because Ryan Reynolds, Leslie Sloan, and the New York Times, they did not have first-hand knowledge, i.e. they weren't there at the moments that Lively is saying she was sexually harassed. So they don't have first-hand knowledge. They are relying on Lively's statements that to that effect, that she, you know, she says, I've been sexually harassed. They have no reason to disbelieve her. And that is why the judge said that there was no actual malice with those three. But he did not extend that to Blake Lively. And she is trying to say here, where is it? The court's finding that Mr. Reynolds and Miss Sloan and the New York Times acted without actual malice, by extension, suggests a lack of malice on the part of Miss Lively as well. I don't agree with that. Firstly, she has the first-hand knowledge. So it is not the same. It's not, well, you didn't find actual malice for these people, so therefore you shouldn't be able to find actual malice for me. She is a different person in this. She is the person who was there and has the first-hand knowledge. The other people do not have first-hand knowledge. Furthermore, his ruling, rather than, if you turn it on its head, rather than actually extending it to Lively, he specifically excludes her. If the judge had wanted that finding that there was no actual malice to apply to Lively, he would have said that. But he did not. And I think that's one of the things I would like to see Wayfarer turn that comment on its head a bit. So, yeah, the fact that the judge didn't mention actual malice, it doesn't tell me anything at all. And I don't think that. I think Lively is attempting the impossible, really, to try and get the judge to say, well, you didn't find malice for these people, so, you know, it stands to reason that I didn't act with malice either. And there is, you know, there's going to be a reason that she's going to be treated differently, which I will go through in a bit. So yeah, that was what's that? That's footnote 15 in the motion for fees and costs and damages. I mean, she's brought up the whole thing with Friedman and the Madison Square Garden thing. I don't know why she's hanging on to that. I think this is really speaks of desperation. And then she has a moan about the internet sleuth community, which is rather ironic. I suppose one thing I will say on this, as someone who was subpoenaed for what I said and the views I've shared about this case, a lot of my views were also around my domestic violence situation too. And I've said this before, and this feels like the right moment to kind of say it again. If anyone has felt like they have been subjected to a retaliation campaign, it is us content creators who are subpoenaed. Because the vast majority of us were talking about this case because we had, you know, varying degrees and levels of domestic violence, sexual harassment, sexual assault, false accusations even. You know, some of the people have been in the situation where they've been falsely accused. So we've all openly shared some of the stuff, talked about why the film mattered, the marketing was devastating, and it felt like a letdown. And the response we got to that was a subpoena for our personal information, our bank accounts, our backup email accounts, all kinds of really personal stuff, our location and various things. Just completely unnecessary stuff. And then when we filed something with the court to say we weren't happy about it, it was sneakily withdrawn, and an impression was left by Ezra Hudson to falsely suggest that we had met and conferred with her when we hadn't, and we had given her the information she was looking for, so now she no longer needs a subpoena, and that was a lie. So I find it a bit rich that she is here filing this, talking about, you know, she wants protection when she subjected us to that because we didn't believe her. What else we got? All right, so she's obviously saying her statements, her allegedly defamatory statements, are privileged under section 47.1. Yes, but they have to be without malice. So let's just go to that now, actually. When did I do this? Okay, so this is a part of a thread that I wrote back on the 21st of March. This was actually in response to, I think this was Blake Lively's motion to dismiss. It was one of the first threads I actually did. And what I wanted to do here was, I went through the actual filing, but then I really looked into this section 47.1 because it was so brand new and it took a lot of people by surprise. So I didn't understand it. So I went away, I looked into it. And I did a couple of separate posts about California Civil Code section 47.1, which is the sexual harassment privilege that Lively is asserting in a motion to dismiss. Important point, it does not automatically apply just because Lively has complained of sexual harassment. So she does say, well, I didn't even have to complain. And that's true. She doesn't have to have complained, but it also does not automatically apply just because she did complain. So this is section 47.1c. This section shall only apply to an individual that has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. And this means that the complaint must be made in good faith and there be a reasonable basis for this. And for me, I wanted to unpick it all. Because section 47.1, it has legal definitions. So the starting point was the definition of sexual harassment. What is sexual harassment under California Civil Code section 51.9? Subsection 2. The defendant has made sexual advances, solicitations, sexual requests, demands for sexual compliance by the plaintiff, or engaged in other verbal, visual, or physical conduct of a sexual nature or of a hostile nature based on gender that were unwelcome and pervasive or severe. That's the legal definition under the California Civil Code of sexual harassment, sexual harassment. So, for me, now bear in mind this is back in March. This is when we didn't have a lot of discovery, and although we haven't really moved much in terms of discovery on the sexual harassment claims itself, I took the allegations that she made in her CRD, in her complaint, and then what Wayfarer's response was. So when I broke down her allegations, when looking at her allegations against the evidence from both parties, I am struggling to see how they could be considered sexual in nature or of a hostile nature based on gender. And this was my opinion at the time, and it hasn't really shifted. Use of the word sexy. This was a director describing the particular look of a character's wardrobe, not her wardrobe, a character's wardrobe. Lively had herself set a precedent for the use of the word in this context. It is difficult to see how she could claim it's unwelcome or uncomfortable. Because you remember, she was actually the one that said, I'm going for this look. I want it to look sexy in those text messages. So, Justin Baldoni, it looks like he just mirrored himself to her energy and, was using the word because that was the word she was using herself. So I think she's going to have a hard time arguing that she was made uncomfortable. Demand for intimacy coordinator at all times. My starting point here is that there was an intimacy coordinator, which goes against Lively's original implied claim that there wasn't. SAG-AFTRA only recommends the use of intimacy coordinator. It does not mandate their use. So it's not mandatory to have an intimacy coordinator. It is recommendation. Also, Lively's delay in signing her nudity rider will likely weaken will likely weaken her argument here, as the nudity rider allows her to set her own boundaries for intimate scenes So if it is of importance to her, she had an opportunity to input how those scenes were acted out. Because that's what nudity rider is. That's her saying, these are my boundaries. The fact that she delayed signing her nudity rider and filling it in, it goes against her, her claim that she wanted an intimacy coordinator on set all times it was needed. They hadn't even filmed the intimate scenes in the first half of filming. That was done in phase 2, where, by Lively's own words, everything was fine. So I think that's going to go against her too. The home birth video. Now, this could be argued that she was shown something once that she objected to seeing. However, it's clearly not of a sexual nature. And the fact that she's changed her position on calling it pornography is telling. Friedman may imply she may have misinterpreted other instances. So Friedman might, strategically now, because she got the dance scene wrong, she got the birth scene, the birth video wrong, and misinterpreted them. So Friedman could theoretically now say, well, how do you know you didn't misunderstand that, or you didn't misinterpret that? I would. The home birth would also not be considered of a hostile nature based on gender. And the fact that a birth scene was being filmed supports Baldoni's argument that it was merely part of a creative discussion. Improvised kissing. Baldoni vehemently denies this and claims Lively was the one to do this. Lively, in her amended complaint, admitted she improvised kissing. There will also be video evidence of this, so it won't be too hard to prove or disprove. And I think we've seen some videos floating around, where people have put them on TikTok. Asking about weight or talking to her deceased father, they're clearly not sexual in nature or hostile in nature based on gender. The birth scene. At the time I wrote this, Anne Monshine hadn't come out and spoken, so now we've got that as well. Lively falsely suggests that the actor hired for the OBGYN role was not from a talent agency. He was an actor, more highly qualified and experienced than she is. She takes a dislike to the fact that he's Baldoni's friend, but is happy for her sister to get a small role. Additionally, Lively has now backtracked on the allegation that her genitals were nearly nude. This appears to remove the sexual nature element of sexual harassment that was originally implied. And I'll say this a lot, the one bonus of looking at all these different dockets is what I see filed in New York, it's often quite different to what I see filed in Texas. Lively describes the same situation very differently. In New York, she is not so nearly nude anymore, but in Texas, she's completely nude. So I'm sure that will come up, So entering her trailer. Both times, Heath or Baldoni are alleged to have entered Lively's trailers. They were invited. Heath attended with other people who are, again, I'm not sure why they're not part of the lawsuit. Because if they all wandered into her trailer, why is it just Jamie Heath that's being accused of sexual harassment? He entered for a scheduled meeting and had not been informed of any change to the meeting. He offered to leave and Lively declined. Baldoni was invited over text whilst Lively was pumping. So, how can she express discomfort when she knew that people were coming to her trailer and she could have said, sorry, could you come back? The slow dance scene. It clearly did not happen as she suggested. Baldoni did not nibble her lip, but we have seen video of her nibbling his lip. He did not refer to her personally as smelling good. He said her spray tans did. and he was not nuzzling her neck. She did not look uncomfortable, and there was nothing sexual or of a hostile nature based on gender. So, and that doesn't cover all the allegations, but these are like the bigger ones. But when you actually put them against the legal definition, they don't meet the definition of sexual harassment. And this is, like I say, this is a 6-month-old post. It's one of my first ones, and I really went to town on the detail on it. But I stand by it now. That is the definition. So defendant has made sexual advances, solicitations, sexual requests, demands for sexual compliance by the plaintiff, or engaged in other verbal, physical conduct of a sexual nature or of a hostile nature based on gender that were unwelcome and pervasive or severe. And don't forget that it's not just that they're unwelcome, they also have to be either pervasive or severe. And it's none of that is really meeting those elements. So I also did actual malice, but I just want to go and check chat. Oh, thank you, Millennial. I love you too. What's the chance that it's Liz Plank or Ryan Reynolds? I'm taking it that we're talking about the anonymous declaration, which I will get to. I'm saving that for last, actually. Will they both be deposed? Yes, they will both be deposed. Liz Plank and Ryan Reynolds will be deposed in this. Yeah, don't forget to like the video. I heard Blake Lively has crunchy hair. Well, that's because she doesn't have conditioner in her hair care range. I mean, who does that? Thank you, darling. Appreciate that. Right. So I'll go and look at the post for So and here as well is I will put a link to this particular thread. But this is the actual section 47.1. So there is absolutely nothing in there about you've got to, end this ordeal for victims at the motion to dismiss stage. It does not say that. I think it's disingenuous for her to even suggest it. So the next post. Oh, right, where is it? Right. To assert sexual privilege, sexual harassment privilege, Blake Lively needs to have complained of sexual harassment in good faith. Now, I covered the definition of good faith. That was the post I've just read. But she also has to have made the statement without actual malice for the privilege to apply. I've been asked to do a post on the definition of actual malice. So here is that post. There's also a case law here, Bose Corp against Consumers Union of the US Incorporated. To show actual malice, plaintiffs must demonstrate that the defendant either knew his statement was false or subjectively entertained serious doubt his statement was truthful. Right, so in the previous post, I went through the various allegations and showed where I believe that Blake Lively knew her claims were not true. The definition of actual malice is under California Civil Code 48A-D and defines this as, I've actually got 48. I'll go straight to D. Where is it? D4. Actual malice means that state of mind arising from hatred or ill will toward the plaintiff, provided, however, that a state of mind occasioned by a good faith belief on the part of the defendant in the truth of the libelous publication or broadcast at the time it is published or broadcast shall actual malice. So we do actually have a legal definition of actual malice. Here, there are so many elements that could be described as hatred or ill will. This list I put, again, back in March, is not exhaustive, but it's just some of the things that I thought of at the time. We will be hearing more because of discovery. And just because Wayfarer's claims were subsequently dismissed for a lot of this does not mean that they cannot use this as defense. So just to keep that in mind. Evidence of actual malice. The takeover of the film. Clearly an obvious one. The removal of Baldoni's image and a film by credit. Why did she need to do that? Like, you know, she's got an argument and say, well, I just wanted to help, you know, and I was doing more than I was asked to do, and I did it for, you know, nothing. I didn't ask for anything. But why does someone remove their co-star's image from the poster art of the film that you're both starring in? And specifically their credit, they're a film by credit. There is no real need for her to have done that. That was just spite. The leverage used with Taylor Swift's song. The demand for the PGA credit. The references to the allegation in Deadpool and Wolverine. The nice Paul character, and the reason I say this is because Lively herself claimed credit for influencing the character's development, according to her own Instagram post. Yellow. So this is her post. All the ways we've influenced Deadpool movie, and one of them being nice men who use feminism as a tool. The drafted statement for Wayfarer to take quote-unquote responsibility, and the use of his words from his books in that statement to further harass him. Again, that's really spiteful. That's, to me, I took that as an attempt to demean his entire brand. If you're putting together a letter of taking responsibility and apologizing for failings that you want someone else to put out in their name, and they take responsibility for your missteps, but you also use excerpts of their books which have no bearing on the situation just to mock them, I call that ill will or hatred. The refusal to allow him to attend his own premiere under less humiliating conditions. The fact that she would not just get on the red carpet with him. The guy it was his film. His company was paying for the premiere and the after party and everything, but she wouldn't let him be on the red carpet. I find that terrible. And then the segregation and poisoning of the other cast members from Baldoni. So right now, at another time, this assumed that evidence, if not already available, will come about in discovery for these points. And Baldoni only really needs one of these. He just needs to prove that there was actual malice. He doesn't need, loads of these points. He just needs one of them. At the time, I said I think the strongest one will be the evidence that she used the allegations as leverage to extort something from Wayfarer. And I still stand by that. I think that is the strongest. But I also think the removal of his image and his a film by credit from the poster art is incredibly strong. I do not know what answer she gave in her deposition, because she will have undoubtedly been asked, why did you do that? What was the purpose and what was the objective? And I can't see what reasonable, acceptable answer she's going to have that Justin Baldoni, her lead co-star and director, could not have been on the poster art with her. So that's why I think I'm not worried by this filing for from her for the Section 47.1 motion, and I still remain quite confident that Wayfarer will be able to defend their themselves against her claims. I'm just looking at the chat. Oh, so many people here. Hi, virtual tourist. Oh, hi, Hans. Okay, so I will put the link to that thread in. You know, it's coming around quite a bit, that thread, because these are quite important points. You know, just because she's saying, well, I've been sexually harassed. Okay, yeah. That you know, she doesn't have to have made the complaint, but the allegations have got to meet a standard. And good faith has a standard, and actual malice has a standard. These have legal definitions, so she can't just throw it out there and then that it sticks. Right. Let's go back to the filing. So I see a lot of problems with this filing already. And I think, again, the definition of actual malice, you know, the judge did have, there is clearly evidence there. Like, you know, yes, the judge said, well, Lively did extra work on the film, you know, that was outside of her job role. But I think the reason the judge did not find that she did not act with, the judge did not make the ruling that Lively did not act with malice, because, you know, first, like as well as her having first-hand knowledge, there are these question marks. There is this evidence. There are things to, you know, to continue discovery for, possibly questions for a jury to, you know, answer over her motives behind the work she did on the film. Did she leverage Taylor Swift's song? Why? And so on and so forth. I think the judge was open-minded to that. Now, she's saying that all her communications are effectively protected by Section 47.1. That's not quite how that works. You know, as we've just discussed, they have to be made without malice. And she's saying that they were made without malice. Yeah, I'm not quite convinced. Right. We're going to be, so I'm going to be going to the declarations now, I think. There was just one thing I wanted to go to. Just looking for it. It's one of the footnotes. Ah, yes. This one. I actually can't believe they put this in here. James Vatuska. He's an idiot, isn't he? I'm amazed that they even reference a declaration by James Vatuska. Yeah. James Vatuska, declarations now, these in this lawsuit, they are losing value thanks to James Vatuska, who cannot make up his mind where he stands in this case. Anyway, I just wanted to rant about James Vatuska. I don't like that guy. Right, so I'm not even going to look at Ezra's declaration. My personal experience of having to deal with her is she distorts the truth. I don't trust anything she says at all. So declaration of who knows. I'm curious. I don't know who this is. Now, one thing I will say is the Bates number, which no, I don't know what I'm doing here. No. Oh. Sorry, technical difficulties. But the Bates number here is BL. I did think that this was Blake Lively's declaration initially. I was speaking to Lauren before she went live last night to do her reading of this, and we were both thinking, oh, it sounds like it's Blake Lively's, and the Bates number certainly made me think, oh, it's Blake Lively's. However, the when I read the memorandum and it talks about this declaration specifically, it references someone who is working with Wayfarer on an unrelated project. So not part of the Ends With Us. So that made me think, okay, it's not Blake Lively. It's thrown me a bit a little. If I had to put my guess on it, I think it could be one of the Sony executives. There's one specifically who I'm just looking for his name now. Tony Vinciquera. I probably butchered his name. Now, at the time, he was the president and CEO. He was the CEO of Sony Pictures. He stepped down on the 2nd of January 2025, but this is the guy who came out. It's speculated that he's the one that's responding in the text messages over the Taylor Swift song, where Jamie Heath's like, well, can I call and we'll talk about it? And he's like, you know, if you don't want to do this and you're going to hurt the film, blah, blah, blah. There's speculation that this was that guy, but it's not 100% certain. But this is a guy who came out and said, you know, fully supporting Blake Lively when her allegations come out, and she said, oh, I'll do another 12 films with her, and then the next couple of weeks he'd step down. So yeah, I'm not sure what to make, but it sounds like this person, I don't know. And I've seen a lot of people say Liz Plank. It could be Liz Plank, but I feel Liz Plank may have been the one who heard the comment about spending 100 million to ruin the lives, blah, blah, blah. Heard the comment at the film premiere. I'm not sure Liz Plank was part of this, but she may have been. I don't know. It's fun speculating. So, declaration of we don't know. I, whoever, pursuant to etc., hereby declare as follows. Right, so we know that this person is over 18. of sound mind and otherwise competent to make this declaration. The evidence set out in the foregoing declaration is based on their personal knowledge, right? And we don't get much information. This is the issue. So we know who Wayfarer are. We're told who Wayfarer are. They had repeated negative interactions with Mr. Baldoni and his associates, including verbal abuse by Mr. Baldoni. Mr. Baldoni, I reckon this redacted, though. I don't know. That someone didn't allow Mr. Baldoni to be permitted on set during the majority of production as a result of those experiences. It really tells us nothing. I requested that he not be involved in something marketing or public relations efforts. You see, we haven't heard of any issues with Justin Baldoni during the production of any other film. I looked before I come on here, was there any other issues with any other films? And I can't see anything. My thought was, could it be something to do with Eleanor the Great because he wasn't at the premiere and we really haven't seen him in much of the marketing? But there's no reported issues particularly. I know there was a guy on Reddit, like a videographer or something, who claimed to have had issues with him during filming days of, was it Last Days? It was one of the series he did, but he had issues with him, but he follows Ryan Reynolds and Ryan Reynolds follows him. And his issues came from a few years ago. Like, this sounds like it was happening at the same time as the Wayfarer. You know, it sounds like it doesn't really tell you much at all. But apparently, this person was the person that was told that if Blake Lively and Ryan Reynolds cross a line, then, you know, there will be 2 dead bodies, etc., etc. So that sounds like someone that had to be working around the same time or just after the film's production. So I know Wayfarer have got quite a few projects coming out. It could be any of them. So this person was contacted by Steve Sauer's assistant to schedule a time for them and Steve Sauer's to speak. Sauer's assistant did not identify a topic for the meeting. But there's an awful lot redacted. I believe that this declaration, this Exhibit 1, from what I've seen in the actual memorandum, it refers to minute stamps, timestamps. So it sounds like it could be a recording or a video. They may have been deposed. So it could be a deposition video. I don't know. One thing I will say about this, if this person is not related to the Ends With Us movie, they appear to have worked with Wayfarer and Baldoni on a different project. And I'll start by saying that if Blake Lively is getting declarations from people who were not directly linked to the film set she alleges she experienced sexual harassment on, it's telling me she's got nothing. If you can't get a declaration from someone who was there firsthand and saw what was going on, because the judge is not going to do anything with this. It's a completely unrelated situation. It's not even the same film set, by the sounds of it, if it's a film set at all. But the fact that Justin Baldoni has at some point had what may have been an argument, it may have been as simple as an argument, or he may have just had a bit of a short tone. He may have had a bad day. Doesn't it? You know, someone has subjectively come to the conclusion that he was being verbally abused by Justin Baldoni. that's his opinion. Again, that's not been tested. And even if it was some kind of verbal abuse, that is not a protected activity here in this context. That is not what is not. This is not what is at issue, and it does nothing to support Blake Lively's case against Justin Baldoni. So I find this is a ridiculous. Honestly, I'm exasperated with this. Honestly, I see that this is absolutely pointless, and this just seems to be a lot of PR. Because now we're all sitting here going, "Oh my God, who is it?" And it tells us nothing other than it throws out the words Justin Baldoni verbally abusive. We don't know who it is. We don't know what the context was. We don't know what happened. But it doesn't sound great. And the judge is going to do nothing with it. Nothing is bigger than blackmail and evidence tampering. That's true. So the judge is not going to do anything with this at all. Exactly, Christy. It's just a PR tactic by Ezra to change the public's narrative again. Yeah, exactly. That's how this is going to go. She's added nothing at all to her claim. And to be honest, she's now opened the door for Wayfarer to come out absolutely swinging. And I hope they do. Because I've said for quite a while, they need to be coming out harder hitting, more forceful. You know, they need to be dropping some receipts of her bad behavior or to rebut her allegations. Roosevelt, I'm in the minority. I think Lyman will award Blake money from 47.1, even without using 47.1 in his rulings. I think Lyman is a clown with that. But it's possible. No, it's hard to predict what's going to happen, really, because this is uncharted territory. This is a case, this law has never been seen in court. So everyone at the moment is speculating all possible outcomes. Is going to need someone to interpret it. And people will have different of opinion. Some of the things that Blake Lively is alleged in her motion are just absolutely ridiculous. Like I say, you know, there is no mention of someone who complains of sexual harassment, you know, being let out of a lawsuit for defamation at the motion to dismiss stage. But Blake Lively has put that in her memorandum. But the actual law says nothing to that effect. You've got that somewhere buried in amicus briefs, which have been filed gratuitously by people who are on the same board as the likes of Ezra Hudson. She's on the board for at least one of them. You had Leslie Sloan's lawyers as well, I think, had made donations to others. I mean, there was a whole bunch of connections that were made between the lawyers on the Lively party side and some of the organizations involved in the amicus briefs. I mean, I'm hoping that if, you know, although it's not amicus briefs per se, but, you know, Wayfarer have got multiple motions to quash from content creators who are being smeared once again in this document, that they could actually bring out and say, hold on a minute, you know, these content creators make a point of telling you exactly why they don't like you and telling you that they're not part of a smear campaign, and you have no evidence that they're part of a smear campaign because you withdrew the subpoena before you got anything. Oh, hold on. I've just become aware of a huge problem of interpretation. So the declaration in the filing seems to be totally unconnected to the declaration about Sarowitz. Yeah. So what's happening is she submitted the declaration and said, well, this person, Steve Sarowitz said this to this person, but also they had their own negative experience with Justin Baldoni, and they've put in a declaration for something separate. They just happened to have been at both events, kind of thing, if that makes sense. That law is riddled with terribleness. It is, honestly, I'm terrified, right, of a law like that. I can't imagine a situation, where you are accused of the worst thing in the world, right? And there is absolutely no way you can defend yourself or say anything at all in any defense of yourself without being kind of having these treble damages and everything hanging over your head. That is a terrible use of the justice system. That's not helping survivors either. For me, I've always said, if you're going to help survivors, right, put something in place for them. If they're successful, fund their, reimburse their costs. But going through, speaking from my own experience, and I went through a 4-year-long police investigation and all of that, everything that went with that, right? I had to give up my devices. I was subjected to physical examinations. I had to, give evidence on video. I had to have my medical records obtained by my ex's lawyer, by the police, including my psychology, my therapy notes and everything. That, it was part of the procedure. Part of the process is due process, if you want. And I had the choice whether I filed a complaint or not with that knowledge. He had the right to defend himself, though. Why should someone just take my word for it? People lie. So we went through this whole thing, and it took years of my life. Why should she be any different? And the thing is, right, is when you start setting precedents for that, where, for laws where anything and everything can be classed as retaliation, where does that end? Because it's not just going to be, eventually it's not going to be confined to just sexual harassment or sexual assault. It's going to spread into other things. And I mean, I don't like the law at all. I think it's deeply flawed. The whole premise of a justice system is that, person accuses someone, they have their evidence, the other person either comes in and, if they might admit they've done it, and that'll be the end of it. But if they don't, they have a right to defend themselves. They have a right to face their accuser. And I think it is a very draconian law. And the thing is I would rather a guilty person slip through the net and walk free than an innocent person be put through all kinds of hell, have their reputation and their livelihood and their marriage and everything destroyed, their whole lives destroyed over a false allegation. So that's my feeling on the law. I don't like it at all, and they are definitely stretching it beyond what it was originally as well. Those amicus briefs, they really, really did try to stretch Section 47.1. And one of them even said this law was not intended for people like Blake Lively who have the financial means. But she's going to use it anyway. Just looking. And where is Friedman, and why is he not resurfaced in all these months? Do you think he's gone from this case altogether because of Blake Ledge and he's part of the Smith campaign? I think he's quietened down at the moment. He is still the lead attorney. He hasn't gone anywhere. He did her deposition in July. Whenever she got there so many dates for her deposition, I've lost track. Whenever she had a deposition, Friedman was the one that asked all the questions. I think he's just not giving the statements anymore. And if you notice, like, I think it's Ellen Garofalo is doing most of the filing responses. At least it's her signature that's on them. I mean, they are still all working together, but I've noticed that the judge seems to have a bit of a soft spot for Ellen that he doesn't seem to have for Fritz and Friedman. So, yeah, I think that's why they're getting Ellen to do all the filings recently. But Friedman's name is still on those filings, and he is still the lead attorney for his law firm in this case for Friedman, for Wayfarer. No, I don't. No, I don't. I've got a little girl. I mean, I struggle to sleep anyway. I get a bit of anxiety and stuff, but I've got a little girl. She's got a nasal gastric tube, and she's got really unstable blood sugars. So I'm up and down with her, having to check her and so on and so forth throughout the night and the day. Yeah, so that's what that is. Liz Plank. I'll address Liz Plank because P has made a great comment here. Liz Plank is not reliable. No, she's absolutely not. So Liz Plank, we know that Liz Plank has a. I'm just going through my Facebook bookmarks here because I have done this one. Right. Okay. Let's share screen. Was she in the basement at the premiere? No, she was at the premiere. I don't think she was at in the basement. I think she was out with Lively and Reynolds, actually. She wasn't in the photos, I don't think, but she did post about it. She didn't interact with Justin Baldoni. But I think she was definitely she was definitely at the premiere. So I did a deep dive of Liz Plank. I'm trying to get. So she had an existing. Actually, she was friends with Ryan Reynolds before she met Justin Baldoni. What is that? I'm just looking for something now. She excuse the video. So she joined Man Enough podcast I think she got in touch with Justin Baldoni in October or November of 2019. That's when they first got in contact. And then she joined Man Enough podcast in 2021. But this is the one I wanted. In middle of the year to fall 2022, Liz Plank filmed an episode of Welcome to Wrexham called Romance with a W. There's some speculation that Plank may have informed Reynolds about the It Ends With Us project and that they were looking for a lead actress. A few months later, Lively was cast as Lily Bloom. And if you click on the image, you will see that Blake Lively actually credits Liz Plank with her being cast in the role. So this is Colleen Hoover. I think this is like it's now deleted of her Instagram, but it was a video of her or a photo with a cast announcement. No, it was Justin Baldoni, sorry. Sorry. It was Justin Baldoni, so it was a cast announcement. And no, I can't lift it. I can't highlight it. But the top comment there, Feminista Velas. So she's tagged Blake, that's Liz Plank's Instagram, by the way. She's tagged Blake Lively and Justin Baldoni is the duo we deserve. Blake Lively. And then she tags Liz Plank and says, "You're the reason." We know that there is that connection to the film. So, but she was definitely at the premiere. I don't think she was at the basement. I'm not sure what the deal is with Liz Plank. She sounds like an awful person and a friend that I would not want. But I think that she, and I've seen an interview, I couldn't find it, but I've seen an interview where Blake Lively actually suggests that, you know, when she first heard about this, the film, she saw it as a franchise opportunity. And I think that it was Liz Plank pitched the idea to Ryan Reynolds, possibly Blake Lively, and then that's where the plan was started. I think it's always been the goal to take over the film. Right. Oh, the bush birds. Liz Plank, the skank. Yeah. Oh, thank you, Elizabeth. I appreciate that. Oh, she's the love of my life, though, so I don't mind. So that's kind of my my take on it. I'm not worried by this motion at all. I'm really not. I don't think Lyman is inclined to rule on it. I don't think he wants that kind of messiness on his hands. But I also think that a lot of what she's put in the motion, in the memorandum, is just not enough. Like I say, when it gets to trial, she's going to be arguing that she's going to be asked about her claims and her allegations, and it's going to be tested against the definitions, and I just don't think it's going to meet it, is my honest opinion. But we will see. So I think that's it for me for now on this. And we'll see. I'm hoping to get Mandy Magnin on this week. She has agreed to join me. We're just trying to pin down a day. I pitched tomorrow, so I'll see if she comes back to me. But I should have my live as well with my question and answers session with DFJ if she's feeling up to coming back. So thank you so much for joining me and listening to me. It's been I get quite nervous when I'm on my own. So thank you for bearing with me. And thank you very much to my mods who are just amazing and great at supporting me. Appreciate you guys. So good night, everyone. And I will see you again soon.